So this afternoon, Transport Innovation Association is creating a content together with the partners of the projects that we are creating together. In the first session, we will be presenting Admiral project. I will be facilitating the session. My name is Inga Ablingene. I am partner for Transport Innovation Association. And the next session will be moderated by my colleague, Rugilė Ndziukevičiūtė-Buze, who is General Manager at the association and will host the session on digital and paperless logistics. Having said that, I would like to highlight today Admiral, which is the EU-financed project seeking to develop and pilot AI-driven solutions for managing logistics, supply chains, including related missions to reduce transport and logistics emissions, and increase transparency, resilience of logistics supply chains, and stakeholder cooperation. During this session, I would like to invite you to deep dive into the topic. First, learning the legal and practical aspects of the new EU regulation on supply chain emissions. Elena Mickevičienė, who is Associate Partner and Sustainability Team Leader at TGS Baltic, will relieve why Scope 3 emissions are high on business agenda. This presentation will be followed by Elena's colleague, Daiva Dėdienė, Sustainability Projects Manager at Audifina. Daiva will share her insights on the new EU taxonomy regulation, as well as how and when it will affect us. So please, Elena, the stage is yours.
Hi everyone at Transport Innovation Forum. Hope you had a lovely lunch break. I'm Elena Mickevičienė, co-head of Sustainability Team at TGS Baltic, and it's a really pleasure to be here and present a topic which is high on business agenda, the Corporate Sustainability Reporting Directive, or so-called CSRS. Although CSRS is not the only legislation of sustainability to have in mind, in my opinion, CSRD needs your immediate attention due to the extensive reporting requirements and timing. It may seem that CSRD is only about reporting, and it is, and I will talk about it later, but CSRD has a broader aim. The primary objective of it is to change companies' behavior to positively contribute to the environment and society. And of course, to combat greenwashing, which is a real problem nowadays, as the companies are using sustainability as a buzzword without any objective justification. So let's start with the brief overview of CSRD requirements. Environment, social, or governance reporting, so-called ESG, is not a new thing. Financial institutions and listed companies have been reporting for some years. Although CSRD extends the reporting requirements in both ways, to who needs to report and what information needs to be reported. It is counted that 50,000 companies across the EU will be directly affected by the CSRD. Currently, ESG reporting is performed by 11,000 companies. But many more companies will be indirectly affected by CSRD through the value chain, and I will talk about it later. So what are the legal requirements? The legal requirements the CSRD will apply to, first of all, companies listed on EU-regulated market, and it may be EU or non-EU companies. And then I say listed, I mean listed shares or bonds. Also large companies, and large means something under EU laws. It is a company which meets two of the three following criteria. So 20 million asset, 40 million turnover, and more than 250 employees. It should be noted that the European Commission, due to the inflation, proposed to amend these thresholds as indicated in the brackets. Although they are not adopted yet, I'm quite sure they will be in the beginning of next year. And these thresholds will affect not only ESG reporting, but also financial reporting, because financial reporting also have these measures. So also listed small and medium enterprises, large parent groups of large companies, and third countries companies conducting significant business in the EU, which means having at least one branch or subsidiary with a turnover of 150 million euros. CSRD will take place in 4 stages, waves, or phases, you can call it as you wish. So first wave is companies listed on the EU market, and they will report in yearly 2025 for the financial year 2024. Later, large companies and groups, small and medium enterprises, and third country companies. Of course, there are some exemptions, a possibility to postpone, especially for the small and medium enterprises. But in my opinion, the biggest wave will be in year 2026, when all large companies will start to report. As I said in the beginning of my presentation, CSRD has a broader scope. So investor needs to understand what is real impact of the company's activities on the planet and the society. Consumers also need information to make sustainable choices. That's why sustainability information needs to be trusted, reliable, and of course comparable. That's why CSRD makes mandatory to report under the European Sustainability Reporting Standards, so-called ESRS. These standards are quite extensive and detailed. Some of them are cross-cutting and mandatory, like general disclosure, covering such topics as double materiality assessment. Others covers environment, social, or governance topics, and they are subject to double materiality assessment. What is really important, the CSRD is a directive. That means that we, European member states, need to transpose it to the national law, and we are currently waiting for the Ministry of Finance to prepare the draft law. However, ESRS were approved by so-called delegated act, which means we have final text and they are directly applicable in Lithuania. So we can start prepare for the future reporting. And to understand how extensive it is, recently I was listening on a podcast, and the representative of one Dutch company, which was reporting for some years and has a good history, experienced team, and etc., they did the double material assessment and tried to report under ESRS standards. And they discovered that they cover some data points, but it's only 30%. So it's a good example how extensive ESG reporting will be, comparing with voluntary reporting, which is currently also done by the companies. So I have mentioned double material assessment, and double material assessment is a complex question which needs a separate presentation, and I have only 15 minutes. So in a nutshell, it's a tool for the companies to understand which information need to be included in sustainability reports. And materiality has 2 dimensions. So first is impact materiality, and it's not a new thing, especially for the companies which were voluntarily disclosing sustainability information as GRI. And here we need to assess the company's impact on the environment and people in short, medium, and long term. What is really important to note that we need to assess not only on the company's level, but through the value chain. And financial materiality, it's a new thing. And here the focus shifts how sustainability goals affect the company's financing, finance performance, access to finance, and etc. So by combining these two things, the companies will understand which information need to be included in the report and which is not. It's a difficult exercise, and you will need to make a lot of judgments, assumptions. But the good news is that the EFRAG, which is a consultancy agency of the European Commission, will provide you with the guidance how to perform this double materiality assessment. And for those who were attentive, you may notice that I mentioned impact on your entire value chain. Value chain is slightly different term than supply chain, but pretty much the same. So CSRD makes mandatory to report on your upstream and downstream supply chains. And what is important for logistic and transportation companies that CSRD makes mandatory to calculate greenhouse gas emission in 3 scopes. So first scope, scope 1 emissions, is emission directly produced by the companies things they own, such as factory. So it's easy. Scope 2 emissions is mostly emissions from heat and electricity. Although the companies do not produce these emissions, they are responsible for them because they use heating and electricity. And scope 3 is not direct emissions and is from companies' activities, other companies' activities like transporting goods. And the biggest challenges, the biggest opportunities for cost saving are in this category. And it's all, for most businesses, transportation falls under this scope 3, which means that your scope 1 and 2 emissions are other scope 3 emissions. That means that CRD will affect transportation and logistic companies despite their size and despite the thresholds I have mentioned before. So CSRD is a really thing for transportation and logistic companies. You will need to rethink how you operate, and here is what I suggest. First of all, start by understanding your emissions, including the often overlooked scope 3 emissions. You need to identify your data gaps and start gathering data. So you need to invest in data collection and management systems. Data currently is the valuable currency, and if you have data or you have access to data, you will win this race towards sustainability. Collaborate with your suppliers and partners to create more transparent and sustainable supply chains. Trust and long-term partnerships are also really important because you will need to disclose really sensitive information. Really sensitive information on your risk, and you know what it means to disclose your risk to the financial institution. So you need to be sure that your partners will not use this data to make commercial influence. Use technology innovation to reduce emissions, and today and on Friday you will hear a lot about innovation, new tools, how to reduce this emission. Also communicate your progress to customers and investors. I like to say that each step in sustainability matters. So if you can't run, walk. If you can't walk, row, but move towards sustainability. So that's all about CSRD. But as I said in the beginning of my presentation, CSRD is not the only legislation we should take in mind. ESRS makes mandatory to report under taxonomy regulation, and my colleague Daiva will provide you with more detail. Thank you for your attention, and if you have any questions, feel free to ask me. Break.
Hello, everyone. Really very nice to meet such a huge hall full of people. And my name is Daiva Dėdinienė. Currently, I work in Audifina. It's consulting and accounting firm as my responsibility sustainability project manager. And to add to this, I'm also previously I work in the Bank of Lithuania, and I'm also consultative as an expert in EFRA, participating in Digital Reporting Consultative Forum. So I advise to EFRA how to establish economy, digital taxonomy. Maybe you heard about it. Also, I will have one slide about it. So today let's talk about taxonomy regulation. At least we call it taxonomy regulation, but to be honest, there are a lot of delegated acts and laws, and to understand what really taxonomy means. So taxonomy, it's like a system classification of your economic activity in order companies, if we want to prevent greenwashing, there are very strict requirements how to disclose technical screening criteria, and then it's actually not a new requirement. It was applied together with non-financial reporting directive, which is applicable to all public interested entities. Usually people think that it's applied only to listed companies, but that's not true. As you know from our national law, public interested companies, it's a larger scope, not only listed. And non-financial reporting directives means that it's applied only to large public entities. And I will, in my next slide, will show how it is. But let's come back to taxonomy regulations. So it's applicable from 2022, the 1st of January. So it means the companies had already to disclose about their eligibility from 2021. And for 2022, we had to disclose requirements about their activities, which gives substantial contribution to climate change mitigation and adaptation. And from this year, the beginning, already these requirements expands to economic activities which provide substantial contribution to all 6 environment objectives. Maybe it's quite new, but as you can see from my slides, it's already applicable. Also, I would like to mention that this is evolving, and not yesterday, but one day before, on 21, it was already published 2 more delegated acts, environment and climate delegated. Oh, sorry. So this is the timeline about legislation. As you can see, it started in 2020. And as I already mentioned, it's already, let's say, should be updated because 2 days before, 2 more delegated acts were published in official journal. And it's really very related to CSRD because CSRD talks about taxonomy regulation, and as my colleague previously mentioned, about requirements of CSRD. So let's look to which taxonomy is applicable. Does it really affect your company? So it's almost the same nowadays as an FRD requirements, so it's applicable to big public interested companies. That means that your balance sheet, if it's company or if it's a group, so 24, revenue should be not less than 40, or if it's a group, so 48, and more than 500 employees. And all these 3 technical requirements should be reliable, and then you have to comply it mandatory and disclose these requirements. Coming soon from 2025, when you will publish your reports, because for 2024, as you know, so the same requirements as to an FRD, so it will affect big public interested groups or companies, and requirements, let's see, but I do hope that it will be, because of inflation, it will be enlarged to 25 and revenue of 50 million euros, but employees is less, only 250, and you have to pick 2 from 3, not as in this column, all 3. And then compliance is mandatory. Taxonomy regulation is, as I already mentioned, it's really very strict, and it sets all technical screening criteria to all activities, as you can see from the slide. So now, for nowadays, only 9 activities are disclosed and defined. And what I would like to mention, that transport, I even made it bigger a little bit just to see, because transport is already included in taxonomy regulation, and when you have such companies, so you have to disclose. And what is really environment sustainable? So actually there are technical requirements which sets 4 conditions activity must meet in order to qualify as environment sustainable. Here on the slide you can see all 6 goals. It's climate change adaptation. These 2 were improved and previously applied. Now we are going to all the 6. So step 1, at least you have to make substantial contribution to 1. Step 2, you do not have to do any significant harm to any of other 5 environment objectives. Step 3, taxonomy not only about climate, it's also about social issues. So you have to meet minimum social safeguards and comply with these minimal requirements, and then comply with technical screening criteria, which can be qualitative, which be quantitative or both. And all these technical screening criteria are set in another taxonomy delegated acts. Usually people ask, can you give me an example? Because all these regulations, requirements, paragraphs are not really clear. So let's imagine an example that we have a company and it gets incomes from 4 activities. And as I already mentioned, so activities can be eligible or aligned. That means meets technical screening criteria. And as you can see from this, only 3 activities are included in our taxonomy regulations. So that means that the 4th activity, which represents 25% of our turnover, is not included. So it means that company has 75% activities are eligible. And then we have to go through all these 4 steps. And as you can see, the 2nd activity doesn't meet criteria, and because it must not harm to any other of 5 environment objectives. And as you can see this red square, so that means that this our 2nd activity doesn't align, and at the least we have only 2 activities, that activities 1 and the 3rd activity, which is aligned. And then we have to calculate 3 KPIs, so turnover, CapEx and OpEx. Some insights, because as previously regulated, we had some decisions regarding with disclosures, requirements, and so on. So you should always take into account, because usually companies says what we are producing, for example, meal, or some of our activities are not included in taxonomy regulation, and that means that we shouldn't disclose anyone. So my proposal, just always try to read it carefully, and all activities should be considered, not only the main activity. That means that usually companies have transport, they have some buildings, as you see, transport is 6 described in taxonomy regulation, acquisition and ownership of buildings also included. Even if you have rented, it should be disclosed. But nevertheless, there are some possibilities that companies have activities but no taxonomy aligned. So can it be? Yes. And the answer that there is no activity covered by EU taxonomy, no activity aligned with technical screening criteria, or not make substantial contribution to environment subject. It also might make substantial contribution, but not meet the do no significant harm criteria or the minimum social safeguards, when that means that your taxonomy is not aligned. Also, my advice would be companies also should take into account materiality aspects, because taxonomy regulation doesn't talk about not material KPIs. It's only applicable to OpEx and also to a certain degree. That means that even if you don't have any turnover from economic activities, you should disclose it as a zero and disclose and explain why it is so. Transparency is always number one. So if disclosures are not complete, if company cannot get any information, so my advice is always not to forget and explain about it and reasons. And the best way is also to disclose the timeline when you are going to disclose and get all this information. If you do it on voluntary basis, as you saw from my previous slide, so you always have to disclose basis, methods used, and how it differs, if it differs from mandatory information. And also would like to make a point to companies which are should mandatory disclose that last year we had to disclose only for 1 year. This year, when you will prepare your sustainability report for 2023, so comparable information which KPI is published for 2022 should also be included. And for the final beginning, very quickly, just for better understanding, if you choose activity freight transformation services by road, so you can see the description, what this means with activity. You also can check with NACE codes, also pick up the technical scrutiny and criteria, the substantial contribution to climate change mitigation, and as you can see, a lot of regulations requirements, do no significant harm, other 5 environment goals, and what means that, for example, one of them, substantial use and protection of water and marine sources not applicable, and also protection and restoration of biodiversity and ecosystems. So that's the way how companies should apply, should take into account, and also describe this activity. And for the final slide, so as I already mentioned about digital reporting, so you shouldn't forget that from 2025, the companies also will have to prepare their sustainability report or annual report in inline XBRL and tag all necessary requirements, including taxonomy regulations, KPIs. So thank you for your attention. If you have any questions, I'm always happy to connect. And please visit also our company website or contact me if you have any questions. Thank you.